Okay, let's go ahead and jump in. Hi, everyone. My name is Michelle Arkusky, and I'm the Executive Director of Music. If you're new to our programming and joining us for the first time, welcome. If you're not new, thank you for your continued support and joining us again. As some of you know, next month is Women's History Month, and we are packed with exciting panels, workshops, and partnerships. So please be sure to sign up at sheisthemusic.org if you have not already, and follow us on Instagram for more updates and opportunities. We have a really informative conversation today with two incredible guests, and I'd like to introduce Susan Dotis, former major label executive, our She's the Music Global Co-Chair of Mentorship, and music publisher professor of music business studies at NYU's Steinhardt School of Culture, Education, and Human Development.
It's a mouthful.
But hey, we're worth every word. So go ahead, Susan, I'll throw it over to you.
Okay, well, welcome everybody. I know there's so many of you that I've seen before here at She's the Music's Music Business Basics program. So welcome to you guys if you're returning for more torture. No, seriously, more great information. And welcome to all our new participants who are here for what I consider to be one of the most important sessions that we have done at Here's the Music, Choose the Music, that we've done here. Just critically important information, and we have the best of the best with us tonight. So get your note-taking utensils out because you're going to want to get this information down. First of all, let me just reiterate what Music Business Basics is. We do a lot of programming at Choose the Music. This particular series was developed by myself and my mentorship squad, Cynthia, Sarah, Michelle, Nellie, and of course the wonderful Melody. And we came up with this idea of presenting sessions that look at the very fundamentals of the music industry. So many of us work and create in the music business on so many different levels in so many different areas. Yet we have found that many people don't really know the fundamentals of the business, how the key sectors of the business actually work. In addition to that, we have many people who have been longtime executives in the music business who have not been able to keep up with the changes that occur both practically and legislatively that affect the business. And so this is a chance for folks to just get re-educated about what's happening in this business that literally, changes every month. There's something new happening. So we've done sessions on sync, on radio promotion, on marketing, and tonight we're doing a session on what, in my opinion, is arguably the most important sort of strand of knowledge that anybody working in the business can have, because it basically goes to the very building block of the music business, and that is the song and the copyright and how that builds down the line in the business in terms of payment to songwriters and creators. We're going to be talking about that in very straightforward terms, so everybody gets a basic understanding of where that is tonight. And so I want to welcome everybody and let you know that you're in for sort of a great evening. As I said, tonight we're talking about copyright. We all know that the two birth parents of the music business are technology and legislation. And when one of them changes, the other one has to follow. We've seen technology change our business and birth our business from the early 19th century with the gramophone all the way up now to streaming. Whenever those technological changes come into place, it will affect the creator. And in order to protect the creator, legislation has to be passed to adapt to these new changes. And unfortunately, our history has been that legislation comes far later than the actual technological change. So creators are left to kind of flail around and figure out how is this new technology or this new method of distribution and consumption, in our case, streaming, how is it affecting how we, the creators, get paid? And so that's what we're going to talk about tonight with really one of the foremost and most respected experts in this area. So I, as sort of, I come from the talent side, Sirona comes from the business side, but we're both kind of copyright and rights management nerds. So it's really great that we're both here talking about this together. So I want to just give you a little background on our guest tonight. Sirona Elton is a very respected expert on mechanical licensing, royalties, rights management, and music business information management. She has held various positions at Warner Music Group, from product management to repertoire data services. She's also been a senior executive at the former EMI Records Group. Remember when we had EMI Records? She holds numerous degrees. It's amazing. In finance and music media, and also a JD degree, a law degree from Brooklyn Law School. And currently she is the head of educational partnerships for the Mechanical Licensing Collective, which we will be talking about tonight, which is a new rights management organization that came out of the passage of the Music Modernization Act. And she is also a professor and associate dean at the Frost School of Music at the University of Miami. Wow, she's totally amazing. She's one of my heroes. As a former music business executive, A&R executive, and now a professor myself, it's a real pleasure for me to be sort of sharing the same screen with her tonight. So let's give a virtual welcome to Sirona Elton. Welcome, Sirona.
Oh, you are you are way too kind. It's a very surreal thing listening to someone introduce you like that, and you're like, who are they talking about? And I'm honored to be here. I'm such a huge fan of She's the Music. It's amazing. I'm just so honored to be here. And Susan, and we can share this with everybody, as you and I were talking, getting ready for this, I think we realized that we were twins separated at birth. It's really kind of crazy, the paths our careers have taken in terms of industry and academia, and the things we're passionate about. And even the way we teach some things to students, we take the same approach. So it's really, I'm thrilled that not only do I get to be here, but that She Is the Music has helped me now build this amazing friendship with my long lost twin sister. So that's really cool. Thrilled to be here.
All right. So before we get started, Sirona, I always like to ask our guests to give us a little bit of your sort of personal journey. How did you get into the business, and how did you get to where you are today?
Sure. So, I got bitten by the music business bug when I was young. I was in like junior high school. And, I just thought, wow, this is really cool. And I grew up in Miami, and I knew people who were local artists. And I started hanging out with them and going to shows and, sitting there listening to business type conversations, and just got really, really interested. And then when I went to college as an undergrad, this is back in the era of locally produced music video programs on cable access TV. Those of you have no idea what I mean. Think of Wayne's World, which just made this great commercial, right? Wayne's World, but playing music videos. And so I got involved in that. Just my passion just grew and grew, so that when I finished that degree, and having worked at two local music video shows, I knew this is what I need to pursue. And so, so the University of Miami had one of the only master's degrees in music business. So it's a little bit of full circle for me. So I pursued that degree, and then moved to New York. My big dream was to work for a major record company. And so it came true. Once I finished my master's degree at UM in Miami, I moved to New York, worked for EMI Recorded Music, worked there for about 8 years. And while I was there, I also always wanted to go to law school. I wasn't sure if I was going to get a law degree, if I was going to get a master's in music business, what I was going to do. And once I moved to New York, I realized, I'm going to get this law degree. I want this law degree. So I went to law school at night while I was working. So it was a pretty overwhelmingly busy time.
Not easy at all.
But, you can do it. You can do it. I'll say that to anybody out there who's thinking about, going back to school or pulling off 2 jobs at the same time. You can do it. If you set your mind to it, you can do it. So, worked at EMI, came up the ladder, heavily involved in some of the things that you said, really the business side of things, working closely on royalties and product metadata before we called it product metadata. We just called it label copy.
Right,
We're working on that, working on mechanical licensing and getting mechanical licenses in place in order for EMI to have, tens of thousands of tracks available on iTunes, the iTunes store when that launched. So working on the business side of things, royalties, data, rights, that kind of is like the sweet spot that continues to be where my work is focused. So I ended up at there, and actually the way I got that job, so here's another little tidbit, I tell my students all the time, I got that job because of somebody I went to school with who was 1 year ahead of me. And so, we got to know each other. They knew, who I was, what I was all about. So when their boss said, do you know anybody? They were very happy to put my name forward, right? You don't want to put that person's name forward. You're like, they might do a bad job and it's going to damage my reputation. And so really it came out of a peer group. Somebody was just a little bit ahead of me who then was able to reach back and pull me forward, right? So that's how I got that first gig. So anybody who might happen to be a student, that person when you're ahead of you, that could be your in. That could be your in. And those of you who aren't students, just look around and see who's just a little bit ahead of you in whatever you're doing, and they could be the one that opens that door for you. So worked at EMI for 8 years. Was homesick, wanted to move back to Miami, did some other stuff for a little while, and then as I was trying to, I was like, I want to get back in the music business. I stepped away for a minute. I just needed a break. But that music business bug, it was there for so long, it wasn't going to just go away that easily. The University of Miami was hiring for a music business professor. I was like, this is perfect. This was meant to be. It was destiny. And so I threw my hat in the ring for that and got the gig. And from that point forward, I have been living this life of what a friend of mine termed a pracademic, which is somebody who is a practicing academic, right? Somebody who does the thing they teach. I mean, we think about it like, do you want, if you're going to learn how to do heart surgery, you hope that the professor teaching you how to do heart surgery actually does heart surgery, right? And so it's just so important, especially as quickly as our industry changes. And so, ever since then, I've had one foot in the academic world, teaching and doing things that professors do, like writing articles and book chapters and all that kind of stuff, as well as working in the industry. And that work has taken me to do work for Warner Music, for Universal, for Sony, and now at the MLC. And really all of that work has been focused on royalties and rights and mechanical licensing. It's that just is the thread that just keeps still there today.
That's fantastic. I completely agree with you when you talk about the pracademic, as you would say.
Pracademic, yeah.
Yeah, because I'm cut from the same cloth doing the same thing. And I think particularly in our field, I always say to my students, you can sit in on my classes and you can listen to lectures and you can read books, but the only way to really learn and understand the business is by being in it and doing it.
That's right.
So being taught by people who are doing it and also have the talent to teach, because not everybody can teach, it makes for a great combination.
Oh, yeah.
All right, so great. So clearly you're the right person to have here for our conversation tonight. So let's, since this is the basics, let's get right down to the basics. We all understand that there is no music business without one thing, and that's the song and composition. No other, sector of the music business value chain can function without the song. So let's talk about that for a minute. Songwriters, they're writing a song, they're putting their head and their heart together, they come up with this great song, they know they have something great, they vaguely understand that they should somehow protect it, and with that protection comes some rights. You and I know that as copyright. Let's talk about it. Let's explain, when is something copyrighted? How do you get a copyright? What does that provide you, et cetera, et cetera?
Fantastic. So here's some really good news. It's really easy to get the copyright, okay? You don't have to go and run somewhere and file something to have copyright protection. So I want to draw that distinction. When you take that creative thing that's going around in your mind and you get out of your mind and you get it memorialized somehow. So you sing that song into a microphone, you capture those sounds on your computer, you write those lyrics on a piece of paper. Once you get it out of your mind and into something that you could share with somebody else and say, hey, look, listen, or look at this, copyright starts right then. That's the beginning of copyright.
Right?
That's the tangible medium. That's right. It's got to get out of your mind and onto paper, recording. It just has to be something that you could then turn around and say to somebody, listen to this, look at this, watch this, read this. Those are all tangible mediums. And as soon as you get it out of your mind and into a tangible medium, booyah, copyright just happened. The copyrights begin, your copyright ownership begins then. Now, there's a couple of, nuanced things we can get into that I'll summarize in saying, if before you did that really cool creative thing, you already agreed ahead of time that that thing you're about to create is not going to be owned by you, that the copyright is going to be owned by somebody else. Like, let's say, let's pretend you work for a magazine and you are creating, images that are going to be in the magazine, or somebody has hired you to create music for them specifically for something. You might have agreed before the creation happens that this thing that you're about to create, you're not going to own the copyright. So that does happen sometimes. When that happens, you should know it because you would have agreed it already before the creative thing happens. But if that has not happened, like this is you in your home studio, this is you riding a bus and, these thoughts come to your mind. Copyright happened, it attached. As soon as you created that thing in that fixed medium, you became the author and the copyright owner right then. Copyright registration, which we can get into, people sometimes think that copyright protection doesn't start until you register your copyrights with the U.S. Copyright Office. That's not true. There's a lot of reasons you should do that. There's a lot of benefits, really important benefits that make it worth the effort, worth the money. And guess what? It's easy enough for you to do it. You don't need to hire a lawyer to do it. But people think, oh my gosh, I thought this song up 3 days ago. I thought this up and I recorded it on my phone. I have to, if I don't race to register the copyright tomorrow, it's like the copyright protection's not there. That's not true. The copyright protection started as soon as you created it. You should register it. We can talk more about that. Lots of great benefits. It's the right thing to do, but it's not a barrier to having copyright protection.
I would mention, as I say to my students, the most important thing to know about taking that simple step of registering your works with the Copyright Office, the US government office or whatever country you're living in. The most important thing is, if in the world we're living in today, where people are suing each other for copyright infringement right, left, and center, Katy Perry is suing Ed Sheeran, who's suing Madonna, who's suing this one and that one, right? The benefit of registration is it creates what's called prima facie evidence of ownership. It's official evidence that you are the creator and at that moment, the owner of the copyright. So that allows you the right to sue in court if you ever needed to. So that's one of the main reasons why you want to go the distance and sign up, list your copyrights with the government, with the US Copyright Office. But as Sharona said, the minute you create that tangible medium, you get the protection of copyright. So now that you have this copyright, you wrote this song, you have it, what does that mean? What does that copyright provide you with?
So it's a form of property ownership, right? It's ownership over intellectual property instead of, personal property, right? Like your phone is personal property, your house is real estate, real property. This is a form of property. You own it. It's intellectual property. And what it means to have that ownership is it's about control. That's what ownership means. It's control over what happens with that thing, who can use it, how they're allowed to use it, how much they have to pay you if they're going to use it. That's the crux of what it means to own a copyright, is that you have control. We're going to get into some topics later where sometimes you don't have control, but we'll get to that in a minute. Let's start with the baseline that says if you own the copyright, you are in control of what can be done with that thing you created. That's what it really means to own the copyright. And actually, you let me know when you're ready, but I have a cool diagram that we can check out in a few minutes that helps explain what does that ownership mean? Like, what does that mean? So we can get to that. You tell me when you're ready.
Well, we're almost there. So we understand that now our songwriter wrote this song, made a tangible copy, has copyright protection, understands that they have control and exclusive ownership at the moment of that copyright. So anything that happens with that copyright, it's down to them. They get to decide how that happens. So because we're talking about music, we're going to talk about kind of the three main rights that go with this copyright ownership that the copyright owner has the decision-making power over. So the first right is the right to who's going to record this song, make a recording of it, and then distribute it and sell it. So the copyright owner has the right to determine who's going to do that. Second of all, the copyright owner has the right to decide, kind of, who's going to get to perform this song publicly, right? Is it going to be played on the radio? Is somebody going to play it live at a venue? Is it going to be played in the lounge at the airport, right? The copyright owner has that right. And the third major right is the copyright owner has the right to determine where that song can be used in connection with a visual, like a film or a television advertisement or a TV show, or wherever there's a visual image linked with the music. That's called sync. So we're going to look at these three rights tonight, and all the time remembering that the copyright owner, the creator or somebody else, is the one that has the exclusive rights to determine how this song is going to be used. And once the copyright owner determines how it is going to be used, they then can expect compensation. And that's the key here. How do I get paid? Where are the Benjamins? I want to know about that. So Sirona, you want to pull up your chart and we can go over these rights that are exclusive to the copyright owner.
Fantastic. And while I pull that up, because I saw a couple comments in the chat, I think it is definitely worth pointing out, we are advocating that you register your copyright. So we 100% advocate that. But it's not the end of the world if you didn't rush out and do it as soon as you created the work. So the copyright protection begins right away, but we are both absolutely 100% advocating you register your copyright.
And
okay, so it's super easy. So are you able to see that okay there, Susan?
Yes, perfect.
In presentation mode? Okay, so let me just give you guys a little overview of this slide. So across the top, there's 6 columns. Those 6 columns correspond with those exclusive rights Susan was just mentioning under the copyright law. The copyright literally lays these out. You have the right to do this. You have the right to do that. That's in the copyright law. And that's what those 6 columns across the top, that's what they mean, okay? Now down the left, we have 2 different rows. One is for the musical work, right, the song. The other is for the sound recording, right, the recording. A lot of you are songwriters. A lot of you also record your own songs or other people's songs. So that's how you understand these 2. The top is the rights, and down the left is whether we're talking about the musical work or talking about the sound recording. And now what's in the middle, what's in all these little boxes are examples of the kinds of activities that we do all day, every day, the way we consume music, we experience music. Those are examples of the way we experience music and which copyright rights are connected to those experiences. And then frankly, each of those experiences has its own way of generating revenue. It's got its own set of rules about how somebody gets permission to do it, and its own set of rules about how many, what's the royalty rate paid, how is it collected, right? So that's what each of those little areas in there, and we're going to talk specifically about the ones that Susan just mentioned. But you can, you're taking this in for a second, right? How do each of these different things work? And obviously we only have like an hour today, so we're not going to go through every line item, not even close. But this is a good kind of, I use this in some of my classes just conceptually to understand how the rights under copyright, how they line up with the way we experience music, okay? And so what we can do, and you tell me, Susan, we can start off talking about that reproduction and distribution AKA mechanicals. So, all right. So what I've done here is I've called out exactly what we're talking about when we talk about mechanicals, right? So we're over here in this reproduction and distribution, that intersection of those two rights, reproduction and distribution rights of the musical work, right? That's what we're talking about. We're talking about mechanicals. And when you talk about putting music out on a CD or a vinyl record, you talk about putting it out on an interactive streaming service. So like Spotify or Apple Music, right? Interactive streaming means that you as a consumer get to decide exactly what track you're going to listen to. And you could play it like 10 times on repeat if it was your favorite track, right? That's what makes it interactive. And downloads. So any of those kinds of uses of musical work, those all require a mechanical license. That's what we talk about. We talk about mechanical license. So there's a couple of key things I thought I would touch on briefly, because we could spend more than an hour on mechanicals. We won't do that too. But so voluntary versus compulsory. So you guys might have heard this word compulsory. And you're like, what does that mean? That's like not a word you walk around saying every day, right? Like, hey, what's compulsory? Who says that? Okay. Compulsory, you can think of another word is statutory. You could substitute the word statutory for compulsory. What it means is that the law gives the permission. So in a voluntary license situation, I'm contacting you and saying, hey, Susan, can I have a mechanical license? And you would say, hey, Serona, sure, you can have one. All right, that's a voluntary license. I asked for permission, you gave me permission, we enter into a license, it's voluntary. In a compulsory situation, I don't have to ask Susan, and Susan can't say no. The way it works is I look in the law, and the law says, if these conditions are met, if X, if Y, if Z, if these conditions are met, the law grants you a license. You get the license from the law. You don't have to go and ask for it. Now, it means, it's not like, and that's it, super easy. The law is going to require me to pay royalties. The law outlines, very specifically what the conditions are that have to be met. There's things that I have to file and send to people, and then I have to pay royalties. So it's not like all that kind of, stuff that goes on in a voluntary deal where we have to send each other papers and I have to pay you. That's still there, but all of that is not something that we negotiate. It's all set in the law. And so there is mechanical licensing. Some licenses are done as voluntary licenses. Some are handled as compulsory licenses. We'll get a little more into what the MLC is all about, but I'll give you a preview. The kind of license that the MLC is involved with for mechanicals is a compulsory license. It's a license that's granted by the law. So I just wanted to kind of get you up to speed on that piece of terminology. Before I jump down, Susan, is there anything you want me to touch on, or you want to touch on there?
Yeah, I just want to clarify one thing. The difference between a voluntary and a compulsory license, as Serona said, is the fact that in order to get this compulsory or required license from the law, the user, the person who wants to use the music, has to meet a certain set of protocols. And like Serona said, you have to pay royalties, you have to notify the copyright owner. There are laid out rules that you have to follow. The key rule, however, and this is where I think our audience this is information our audience would be able to use, is the fact that you can get a compulsory license if you want to make a cover recording of an existing song. So what do I mean by that? A cover recording, which should be defined as a new recording of a previously recorded and released song, simply means that I want to record a cover version of Yesterday, which was written by Paul McCartney and John Lennon. If I want to do that, I can get a compulsory license, because one of the requirements of the compulsory license is that if the song has never been recorded and distributed before, you can't just get that license through the law. You have to go directly to the copyright owner. Because let's say I wrote a song and Serona wants to record it. If it hasn't been recorded before, maybe I want to record it. And since I'm the copyright owner, I have the first use right. right? So if Sirona wants to record it, she has to ask me. If I already recorded it and put it out, God forbid, it would bomb, trust me, and it bombed, but the song was great. Sirona could then say, listen, you put it out, not so good. Let me have a try at it, in which case she could get that compulsory license. So those of you who are asking in the chat about cover recordings, if it's previously been recorded and released, you can use the compulsory mechanical license for permission.
Exactly, and I'm so glad you expanded on that. That's what I meant when I meant certain conditions are met, and that's that critical condition, which is to say it has to have already have been recorded and released with permission in the United States. Well, we won't get too deep, but that's what's always been the rule. That is still the rule for a lot of these compulsory licenses, but now there's a little bit cool new language in there that is what has created this new MLC for digital licensing that expands that criteria. So, okay, so let me just keep going then quickly. So these the words here, it's easy to understand. If it's a voluntary license, we can negotiate what we want the rate to be, right? We could really agree whatever we want it to be. If it's a compulsory license, then the royalty rate that has to be paid is set by, we call it a statutory rate. There's a particular panel of 3 judges called the Copyright Royalty Judges, and we refer to that 3-judge panel as the Copyright Royalty Board. They set the statutory royalty rates. And so if we're talking about a compulsory license, it has to use the statutory rate. A lot of people, when they do voluntary licenses, just decide to also say, you know what, let's just use the statutory rate. We don't have to negotiate something crazy. Let's just use that rate, and that's their prerogative. But compulsory licenses must use the statutory rate. Here's the big change that the Music Modernization Act created. What was always the case for like 100 years, when you needed to get a mechanical license, the party who needed the license, which was generally the record company, needed to find out for that musical work, who are all the copyright owners of that work. Like, let's say there was 2 songwriters, there might be 2 publishers, and they would have to find out who are all the publishers of this work. And then they have to get in touch with them, either to ask them for a license, a voluntary license, or if the criteria we talked about were met, they would have to send them a notice of a compulsory license. But so we call that work by work licensing, as in you got to find out who the owners are and you got to contact them. For example, sync licensing, which we'll touch on, and some of you guys are doing, sync is done on a work by work basis, okay? That doesn't scale very well when you're talking about things like digital services. And we'll talk more about that in a minute, but what we now have under the copyright law is something called a blanket mechanical license, which basically means you can get one license that covers a whole lot of different works. And I'll leave that there. I'll put a pin in that because I know we're going to get a little deeper into that in a minute. And so now you also have here in the little bottom of the diagram here, this also changed with the MLC in terms of how the money flows. And so what has been the case is that a digital licensee like a Spotify or an Apple Music would pay the publisher pays the songwriter. Now you actually have that service, that digital service paying the MLC, and the MLC pays the publisher and the songwriter. We're going to dive into that a lot more. So I'm just kind of planting those seeds, and we can revisit those if we want to. So I thought, you tell me if there's anything more you want to say about reproduce and distribute, Susan. And if not, we can go to performance.
Yeah, I just want to add that, you know, when we talk about reproduce and distribute, reproduce obviously means to record, but it also means to create a transmission. That's where the streaming services come in. So if you want to record somebody else's song, you need a mechanical license. If a streaming service wants to play that song, create a transmission of it, they also need a mechanical license. So sometimes I find that the word reproduce is occasionally confusing. And when we use the word distribute, that means 2 things. Distribute means to create that transmission on a streaming service. It also means to sell, as in a hard copy, right? To sell a vinyl album or a CD, that's a sale. So I mean, Sorna, I don't know what you think about this, but I always think that the legislators that put together the laws are very clever in their choice of words, because the meanings of those words can be expanded to kind of fit the situation that exists. Because distribute, it means a couple of things. It means to sell, but it also means to transmit digitally. So, and so that word, the meaning of it gets to be expanded.
Yeah, I mean, they spend a lot of time thinking about exactly what word to use. You know, the sentences that are constructed in the law, the choice of terminology. There's a lot that goes into that. So yeah, you're 100% correct on that one. I'm with you there.
Okay, so now that we know that if you want to record somebody else's song and distribute it, you need a mechanical license. Or if you're a streaming service and you want to stream somebody's song on your service to listeners, you need a mechanical license. So let's talk about public performance.
Okay, so public performance in terms of where it lives on this chart, right, for musical works, it's in this column here in the middle. And some examples of that, right, a public performance happens when live music is played, when terrestrial radio like FM or AM, although probably not a lot of AM listeners these days, but terrestrial radio, which is an industry term we use, we're talking about broadcast, sort of traditional FM radio. Interactive streams are also performances. So they need both a mechanical and a performance license. Both three, reproduction, distribution, public performance, all are gonna, interactive streaming touches on those. And non-interactive streams as well. So I described an interactive stream before, right? You go onto a service, you say, that's the track I want to listen to. You play it on repeat a bunch of times. With a non-interactive streaming service, you go to that service, you could pick a channel or a station, they might call them, right? And you like the sort of the traditional Pandora service that we're most familiar with, you would pick that station, but you couldn't pick exactly which track you were going to listen to, right? You can maybe do a thumbs up or a thumbs down. You might be able to skip a little bit, but you don't have complete control over what you're listening to. And so we call those services non-interactive streaming services. But all four of those are examples of public performance of a musical work, and they need a public performance license. Now, while mechanicals world in the US is finally catching up to the benefit of a blanket license instead of a work by work license, in the performing space, in the performance rights space, we have used blanket licenses for a very, very long time. And so these kinds of licenses, this performance license is granted by what we call a performing rights organization. You've heard of some of them: ASCAP, BMI, CSAC, Global Music Rights, All Tracks. These are performing rights organizations. And there's actually, if those of you might be based outside the US, there's at least one in your country as well. And the way these organizations work is they grant blanket licenses to different kinds of licensees. So for example, with live performances, concert halls and arenas need to get a license from a performing rights organization. Radio stations, interactive streaming services, non-interactive streaming services, they all need to get public performance licenses from the PROs. And so the PROs grant those licenses, they collect the royalties from those kinds of licensees, and then they pay that money out to publishers and to songwriters. I want to make a particular point about that because I want to contrast it with something when we come back to the MLC. So the typical model for a PRO is that when they bring in those royalties they collected, they usually pay half of that money to the publisher. We call it like the publisher share. You might have heard that wording before. And they pay half that money to the writers of the song. And so if you imagine you bring in $1, they bring in $1, they're going to pay 50 cents to all the publishers of the song and 50 cents to all the writers of the song. And obviously, if there's more than one publisher or more than one writer, right, they have to divide up their 50 cents. So there's a writer share and a publisher share. And that's the way this is done with performance royalties all over the world. So the rate is generally something that is, it's not set by statute. It doesn't have a 3-panel of copyright judges. It's generally a negotiated rate with some oversight. And so let's pretend, think about, how many nightclubs there are around the country. and all of them need to get a license from ASCAP. So they don't all enter into a really complicated negotiation with ASCAP. ASCAP would have some standard rates that they say, hey, nightclubs, if you know, depending on how big you are and how many people you have and other factors, this is the rate to pay. But it's up to ASCAP to set that rate. If a party like a nightclub, but more likely like a digital service, isn't happy with that number, there is a process where they can ask for a court to take a look at that and make a decision about the rate. ASCAP and BMI, specifically just those two, there's something that we affectionately call a rate court, which is really a federal court in New York City that is charged specifically with having oversight over the rates when the ASCAP or BMI and the party that has to pay the rates, when they can't agree, they can go to this rate court to have them decide what to set the rate. But other than that, for the other PROs, it's a negotiated matter. And if they don't agree, like, if there's a dispute, there's often also abilities to go to, you have to go sue each other in court. There's other ways to go and get assistance in reaching a negotiation, an agreement, like, an arbitrator or a mediator, things like that. So the only other point just to make, so ASCAP and BMI, way back in the 40s, the 1940s, there was an antitrust, anti-monopoly investigation, because they were really the only two games in town in terms of, they had a lot of control. And so there was an investigation, and what happens, it's not unique to music, what happens when the Justice Department investigates a potential antitrust situation, sometimes the way that is resolved is by the parties agreeing something in a consent decree. And so the takeaway from that is that the Justice Department says, all right, you can continue to do what you do. It's okay for you to be a monopoly, but you have to agree to behave this way. And we're going to keep an eye on you. That's kind of a way to think of it. And so these consent decrees were entered into back in the 40s or so. And so that's why you have ASCAP and BMI. There is this oversight over the rates that they set. But these other PROs that are newer on the scene and control relatively smaller market share, they don't have that kind of oversight. But frankly, for a lot of you, understanding what the consent decrees are and what rate court is, probably interesting, but not going to affect your daily life. What you probably really need to be doing is focusing on, if you are a songwriter, which PRO are you going to sign up with? Because you need to sign up with one of them. And then if you also self-publish, like if you are a self-administered songwriter, if you are the publisher of your own songs, you will end up joining one of these PROs as both a writer and a publisher, and you will get both of those halves, as I mentioned, the writer share, the publisher share. If you handle your own publishing, you'll get all of it. So anything else you wanted to touch on there, Susan?
No, only to say that for those of you who are songwriters with songs that are being performed live, even by you, if you're someone that goes to open mic nights, you need to be registered with a PRO. As Sarona explained, only 2 of the 4 PROs are nonprofits, ASCAP and BMI, which means anyone can join. You just simply go on their website, you sign up, I think you pay a small fee or they deduct it from your first royalty check. You provide them with the names of your songs, the writers, etc., and you join. And if there are public performances of your songs, whether that be live or on the radio and a streaming service, you will get paid. The other 2 performing rights societies, CSAC and Global Music Rights, GMR, are by invitation only. It's kind of got a little bit of an elite thing going. So they have a much smaller group of songwriters, and most of the songwriters are very popular and very successful songwriters. Which is why they don't have to suffer under those consent decrees and the rate court negotiation. But ASCAP and BMI pay out hundreds of millions of dollars every year to the biggest songwriters and to the small songwriters who perform in nightclubs, once a month, their own songs. As long as you submit a list of the songs that you perform to your performing rights organization from a licensed venue, you will get paid. So it's really important to remember this. We want to demystify the process that people can't get paid unless they're hugely famous songwriters. That's not true. There are many songwriters who and artists who spend their life on the road playing in small venues, and they get paid, right? Or getting played on small radio stations, they get paid. It's all about understanding the key essential part of this, which is making sure the information on your songs and you is registered in the right place. That's the only way people can find you. So if you're not a member of a PRO, you should look into it in your home country. In the United States, ASCAP and BMI are your best options. Their websites provide plenty of information to make sure that you can register and that you can get paid when your songs are performed.
Awesome. So, so where should we pivot next? I know I'm eager to talk about the MLC at some point.
Yeah.
You tell me, Susan, what's next?
I definitely think that's where we should go to, because the main thrust of tonight's discussion is about this new piece of legislation called the Music Modernization Act, which was passed by the US government, by the Congress in 2018. It's a conglomeration of several pieces of legislation that came about because once streaming became the dominant method of consumption of music in this country, songwriters started looking around and saying, we're not getting paid enough. As a matter of fact, we're getting paid far less than we would have if we had one song on a Madonna album. One song out of 10 songs on a Madonna album is worth 9.1 cents to the songwriter. One song on a Madonna album that never gets streamed because it's not the hit is worth nothing to the songwriter. So songwriters got together along with people like Sirona and lawyers and the National Music Publishing Association and other groups that advocate for creators and said, this can't stand. We can't continue to write songs because we can't make a living. So the Music Modernization Act, through a lot of work and effort on the parts of lots of people who care about music and who care about creators, was finally passed in 2018. And it did several things. It did three main things. One deals with payments to performers for sound recordings. We're not going to get into that tonight. The other deals with streamlining the payment structure for producers and engineers so that they can get paid when music they worked on is streamed. We're not going to get into that tonight. But what we are going to get into is how this changed the way songwriters get paid those mechanical royalties, the royalties owed them when their song is recorded and distributed. Remember, a stream is a distribution, just like the purchase of an album is a distribution. How do they get paid now? So this law changed that, created a new organization called the MLC, of which Sirona is one of the people running it. And she is going to explain to us now, A, what the MLC does, B, how you as a songwriter need to make sure you get in there and get your information to them so they can figure out how to pay you those mechanicals that may have been just sitting around because the streaming services couldn't bother to figure out who deserved them.
Well, you know, this is one of my favorite topics to talk about. And so I will also say, before I really jump deeply into some of the nitty gritty about the MLC. So, you know, there are two related things that are happening that songwriters should want to know about. So the Music Modernization Act, it really addressed things like efficiency, transparency, right? It really, you know, took us forward leaps and bounds in terms of making it so much more straightforward to understand where you need to go to get paid as a songwriter who's handling their own publishing, or as a publisher, to make sure you're getting your mechanicals. How much you get paid in terms of what the royalty rate is, that's actually not something that the Music Modernization Act got into setting those rates. There is that 3 panels of, you know, judges, as I mentioned, the copyright royalty judges. They determine that rate, and that process is a trial. It's like a trial. You have different parties that come and advocate their positions, and so that process of setting the rates and advocating what the rates should be, the MLC is not involved in advocating one way or another. It's our job to efficiently administer and make everything run smoothly, move that money through the system quickly, and get people paid. That's our focus, and that's what we are very dedicated to doing. So what is the MLC? The MLC is a nonprofit. It is overseen by a board of publishers and songwriters. And what we do is heavily driven by what the copyright law said when it set us up. It's very clear about what we are allowed to do, not allowed to do. And we also have regulations that the US Copyright Office issues that also impact a lot of exactly how we do things. So there's a lot of oversight by us, oversight of us, and in particular by people who are the ones who are going to get paid by us, publishers and songwriters. So what are we here to do? So starting January 1st of this year, this new blanket license, it's a lot of words, ready? Digital, mechanical, blanket, compulsory license. So that's a lot. So we're talking mechanicals, hence the name, the Mechanical Licensing Collective. And that means audio only. So nothing to do with video. Video is not anything that we have anything to do with. Audio, mechanicals. It is a blanket license. So it's not a work by work license. That means that like Apple Music, Spotify, they can get one license. And then that covers all of the musical works that are made available on their service, instead of having to find each individual copyright owner of each work and get a license from them. So the blanket license means they have to get one license that covers all of their mechanical uses. That just became available January 1st. And so when a service that is an interactive streaming service or a download service, if they get that blanket license, they then will be paying royalties to us. They'll be paying the statutory royalty rates to the MLC. They'll be sending us the usage information, like which track was streamed, how many times was it streamed. They have to send all that usage information to the MLC as well as the royalty money. We take that information and we try to match that to the musical works information that is in our database. And we want to make that match so that we can pay the party who is entitled to collect the mechanical royalties for that musical work, right? So if you're trying to understand the process, services go through a process of filing a notice and they're allowed to operate under the license. And by the way, you can go to our website and under the How It Works section, you can actually see the list of all the digital services who have now gotten the blanket license. You can see that on our website. So they get the license, and then monthly, they start reporting to us. We've already gotten our reporting for January. They had to report that to us in February of the number of streams, which tracks exactly, and they had to pay us the royalties. We take that information and we match it to information in our database and pay people. So let's talk for a minute though about how did it even get in the database in the first place, right? So the law says our job is to administer the blanket license. Check, we're doing it. The job says we have to collect royalties from the digital services. Check, we're doing it. The law also says we have to maintain a publicly available database of musical works information. Check, we're doing it. Go to our website, it's themlc.com. Up in the top right, there's an option there to search our public-facing database. So the database is there, it will continue to grow. Now anybody can go and search and find out information about the ownership of musical works. So we've got our database, it's there. And we're gonna be paying people their royalties starting in late April. So the data that's there, this is the call to action. This is what I really want everybody who's watching us today to understand about how to get paid, okay? If you are a music publisher, some of you might be listening, you might be working at a music publisher. If you're a music publisher, if you are a music publishing administrator, okay, there are companies that do that. Or if you are a songwriter or composer or lyricist, and you handle your own publishing. If you're self-published, and we call that self-administered, if you handle your own publishing, then you need to become a member of the MLC. It's free. It's free to be a member. You go to the website, same thing, top right, there's a button that says Connect to Collect. That is how you then join. You become a member. There is no fee to become a member. And once you do that, you then register your works with us. You tell us all about your musical works, including letting us know if they've been recorded, who is the name of the artist who recorded them, if you have information like the unique recording identifier that was assigned to that recording, We call that the ISRC. Some of you might have heard of what the ISRC is. We can dive into that if you want. You're going to register your musical works information with us and also tell us about any recordings that have been made of your musical works. And that way, when we get the data coming to us from the digital services, we try to match that recording information from them with information about your musical works so that we can pay you. So that's how it works in a nutshell. We can unpack any of that as deeply as you would like. You tell me. I know we've been talking so long. It's so exciting. I'm like, I have so many more things to say, and time is running away from us.
Exactly. This, just so folks know, at least me, I teach an entire semester's course of this, 12 weeks, right? So we're trying to jam this all in an hour. And Serona, I got to give you credit. You're doing a fantastic job. So let's just go over this. The MLC is a licensing collective that works by providing a blanket license for the songs in their database to streaming services. So if I stream a song, whoever the songwriter is of that song will eventually get paid. The key here is the payments and the service is only as good as the data you have. So this is why we need songwriters. I don't care if you're recording the songs yourself and putting them out there or putting them on SoundCloud or Tidal or Spotify. Songwriters need to sign up because that public.
But let me stop you. Only, so this is the contrast with how it works with a PRO. And this is so confusing. So I'm so glad you touched on this. Not every songwriter should join the MLC. It's not like a PRO. Only songwriters who handle their own publishing join the MLC.
Right.
So let's talk through the scenarios. If you are a songwriter, and by the way, some of you guys wear multiple hats. So let's pretend you've written 20 songs, okay? And 10 of those songs are handled by a publisher, all right? 10 of those songs, there's a publisher that handles those. That publisher will register those works with us. That publisher will collect the royalties from us. They will pay you for those 10. But the other 10 that you wrote, where you handle the publishing, where you are the publisher, you should join the MLC and register those 10 with us. So you really have to look at each song you've written, each one, and say, who is handling the publishing? Because if the answer to all of your songs, if the answer is that somebody else is handling all the publishing, you will not join the MLC, okay? Because you will get paid by the party that is controlling the publishing. But if the answer to any of those songs, any songs you've written where the answer is, yeah, I control the publishing on that song, then you should join the MLC. See, it doesn't work like a PRO where there's a writer share and a publisher share. It doesn't work like that. For mechanicals, all the money goes to the publisher, and then the publisher pays the songwriter based on their contract. So if you are a songwriter, you're not joining the MLC as a writer. You'll be joining the MLC because you are acting like a publisher, right? You've got your publisher hat on. And I saw in the chat a couple questions. You do not have to have created an actual publishing company. You don't have to have created a legal entity and have an LLC or an S corp. You don't have to have done any of that. If you control the publishing, join the MLC, you can get set up. It's not a problem. You don't have to actually have a separate like business entity. But if you are not handling the publishing for your songs, if you did a deal with a publisher, if you signed up with CD Baby Pro Publishing or Song Trust, they are your publishing administrator. You will not join the MLC. They will register your works and collect from us and then pay you. The one thing I will say though, because you might be sitting there going, oh, okay, so actually I don't need to join the MLC because I don't administer any of my songs. That's correct, but here's what I invite you to do. You can still check to see if your data is correct. If I was a songwriter and I had a deal with, you know, Joe Schmo publisher, okay, I would go onto the public search on the website and I would look up my songs and I would look and make sure that they're all there and that the data is correct. And if it wasn't correct, I'd call my publisher and say, hey, Mr. Publisher, I know I can't update the data. Like I can't correct the data myself, but hey, I was looking on the MLC website and I looked up my song and something doesn't look right. Right? That is what every single songwriter can do, anybody can do in our public database. But in terms of becoming a member, where you can update the data, where we will pay you, only parties who are controlling that publishing and have that right to collect the mechanicals directly from a licensee, those are the only people who should join the MLC. So it's different than a PRO. It's not writer, publisher, share. It's a different thing.
So the key takeaway point here, as we sort of go to just a couple questions, is that if you're self-published, if you control your own songs, collect the money, et cetera, everything flows through you, you are a candidate for the MLC. If you have anyone else, as Sirona said, Song Trust, TuneCore, Universal Music Publishing, Sony ATV, Warner Chappell, the big guns, Cobalt, Concord, BMG, any of these publishing companies, they are handling it for you. The key here is that independent songwriters who are running their own businesses can now get paid, and they can get paid for streams, whereas before it was unclear how people were getting their money. And as Sirona can attest to, a few weeks ago, the MLC just got literally a basket full of $424 million in mechanical royalties that needed to be matched to songwriters who hadn't gotten paid. So this is the brilliance of the MLC. They are going to be monitoring the streaming services to make sure that mechanical is still paid. So I just want to get to one or two questions. One question that I see in the question box here, of course, always comes up. Do I need to register with a PRO and the MLC if I'm an independent songwriter? The answer to that is yes, because they deal with two different rights. One is your performance rights, one is your mechanical rights. This one is going right out to you, Sirona. Is the MLC only for songwriters based in the US or also for other countries?
So no, we are based for people anywhere. You can join the MLC if you live in any other country, that's fine. But the one thing I would encourage you to do before that is to do a little homework. Because let's pretend you're based in the United Kingdom and you have signed up with PRS for Music, which includes, that's their performing rights organization, which also includes their mechanical rights organization called MCPS. So if you're in the UK, you may have already allowed MCPS, this organization in the UK, to collect your mechanicals from all over the world. And so in that case, MCPS is going to register your works with us and collect from us. If you don't want them to do that for you, you need to talk to them and find out how you can, what you have to go through with them to have you collect from the US directly. So we are happy to have you. Come on along. No problem. You don't have to be based in the US. But if you are based outside of the US and you have already entered into an arrangement with a mechanical rights society based in your country, you need to check with them about whether or not you can register with the MLC and they won't collect your US royalties or not, or else they'll try to collect, you'll try to collect. So, so that would be the first thing you should double check on, but we're happy to have you.
Okay, one more question. Somebody is talking about they co-wrote a song. So let's just explain, if you co-wrote a song, usually the songwriters split everything 50-50. So if you're one of the writers, you own 50% of the writer's share, the other writer owns 50%. The publisher, your publisher has 50%, they have 50%. If you are a co-writer, does that affect your registration with the MLC?
No, so this is another slight difference to the PROs. When taking your example, you will register that work. And if you are it sounds like, you are self-published, okay? You will register that work and you will register your 50% share as the publisher, okay? Because the publishing on this work is split 50% you, 50% that other person. You will register that work and claim your 50% of it. And that is all you need to do. If that other person comes along and registers their 50%, great. If they never show up, no problem, you still get paid. If they show up and claim 60% to your 50%, then we have an issue, and the money will get slowed down while we sort out how to get you guys to 100 instead of 110. But if you register your 50%, you are good to go. And in that case, right, it's the publishing there in that whole case is 50% to you, 50% to the other person.
So we have time for one more question, and this is a great one. Sirona, you have to know this was coming. What is the difference between the MLC and HFA, the Harry Fox Agency, which obviously so many of us in America understood to be the mechanical licensing and collection agency prior to the MLC?
I knew that was coming. I knew that was coming. That's probably one of
I
our
knew you
top
did.
most frequent questions on webinars. Okay, so the Harry Fox Agency, HFA, sometimes we call it Fox even, okay? They've been around a very, very long time. You know, they're sort of bread and butter, if you will. What they've been doing the longest amount of time is mechanical licensing. HFA is a different organization than us. HFA is a private company, okay? We are a nonprofit overseen by a board of publishers and songwriters and governed heavily by regulations in the copyright law. HFA is a private entity. So HFA is not going anywhere. They're still here. They're gonna keep doing a lot of things. They do a lot more than just mechanicals. They've been involved in physical mechanicals pretty much forever. That was how I first got to know them over 20 years ago. Mechanical royalties for physical products. They also are involved in a variety of other kinds of licensing and rights activities. So they're not going anywhere. They're not changing that. The relationship between HFA and the MLC is that HFA is a vendor of the MLC. So they provide certain services to us. They are a vendor to the MLC. And those services, one of the key services is they have to share the data in their database with us. The data about musical works in the Harry Fox database gets shared with us on a continual basis. And so what that means very concretely is if you are a publisher and you have been affiliated with the Harry Fox Agency, you've allowed them to handle your mechanical licensing forever, they will share your musical works data with us. They have to share your musical works data with us, but you still need to join the MLC because for digital mechanicals in the US, that money will run through us and we will pay you. But for your physical mechanicals, maybe your international mechanicals, you're still gonna get that from HFA, okay? So they will share your musical works data with us. So you don't have to register it in both places, but you do need to be a member of the MLC so that we can pay you the royalties that flow through us. Now, that's if you're a publisher and you've always, been affiliated with HFA. Let's say you're a self-published songwriter, self-administered songwriter, and you signed up, you registered your works with HFA. You were never what they call an affiliate of HFA, but you registered your works with HFA because they were handling licensing on behalf of some big digital services and you wanted to get paid. They are sharing your data with us as well, okay? So at the end of the day, if you have a business practice where you register your works with the HFA, with the Harry Fox Agency, you do not have to also register those works with us. They will share that works data with us. But you do need to become a member so that we can pay you. It's just avoiding duplicate data entry. And so HFA is still around. They're going to do a lot of things. There's one thing they won't do, which is blanket digital compulsory mechanicals in the United States, but they'll still do a lot of other things. And so if you've already had a relationship with HFA, don't change it. Join the MLC and you will not have to do duplicate data entry.
So I know it's mind-boggling, folks. A lot of information. I think we will leave it there this evening. There are so many more questions I wish we can get to, sound exchange, which has to do with royalty payments for sound recordings, a completely different thing. The bottom line here is, as Sirona, I think, so eloquently instructed us, is that if you are a songwriter that is looking after your own songs, you need to know how to get paid. And the MLC is the first place to start for those mechanicals for when your songs are streamed. The performing rights organizations, ASCAP and BMI, are there for you for the performance royalties when your songs are streamed or played on the radio, played live. This is so important for songwriters to understand because there's so much money that accrues every year that doesn't get paid to the people who deserve it because the services can't find them or people haven't registered their information properly. So I urge everyone, and I know Sirona does, to go on the MLC website. I think it's mlc.org. to go.
Actually, it's themlc.com, and I just
Oh,
posted in the
MLC.com.
chat a link to our resources page. We've got FAQs, we've got self-administered songwriter webinars that we've done that tackle a lot of the questions that I'm seeing here that we didn't have time to get to.
Right.
So please visit our website. There's lots of great information there.
Yeah, and join a PRO. Their websites are easily accessible with great information. She is the Music will post a recording of this panel on our Music Business Basics channel on YouTube, which we're working on building, so you'll be able to watch this again. But for someone who has spent their entire career advocating for artists and songwriters, this is dear to my heart, that songwriters especially understand how to make sure they get paid. And tonight you got some great information on how to do that. Again, please use your resources. Continue to join us here at She is the Music for our basics panels. We try to provide information for the person out there doing this on their own. Sharona, big love to you. Thank you so much for being here. We are thrilled to have you. I'm thrilled to have you. We'll do this again, I have no doubt.
Thank you so much. Thank you so much for giving me the chance to help people get paid. I really appreciate it. Thank you.
Thank you always to Michelle Arkusky, who runs everything behind the scenes here, and we couldn't do anything without her. Stay in touch with us at She is the Music, folks. Sign up to our database. We offer all kinds of information and creative opportunities for our members. Always appreciate you guys coming and being here with us. Please stay safe, stay healthy. We will see you again soon. She is the Music. Good night, everybody.